Jay Rayero is a attorney and partner at Bertadotto Law Firm. Jay's practice focuses on the representation of business clients, with healthcare being the core of his practice. His healthcare and regulatory expertise involves the counseling and advising of physicians, physician groups, other medical service providers, and non-professionals. Specific areas of expertise include federal and state healthcare regulations and how they impact investments, transactions, and various contractual arrangements, particularly in the areas of federal and state anti-referral, anti-kickback, and HIPAA compliance. And with that, Jay, I'm going to let you get to it. Thank you.
Great. Thank you. Thank you for having me. Glad everybody can join me this afternoon. So we're talking about patient privacy in your med spa, and this is an interesting topic. Talked to a lot of clients about this topic. And if you've been in the healthcare industry for any amount of time, you've definitely probably experienced patient privacy and the various rules and procedures that you have to follow. When you go to the doctor's office, you probably sign a ton of forms that relate to patient privacy. So we've all experienced it in one way or the other. And at the end of the day, we can boil it down to, and end this webinar within 5 minutes by saying just, protect all patient information to the maximum extent possible. But a lot of times in the real world, when there's a real world application to patient privacy, we start butting up against what we're trying to do from a business perspective versus what are we illegally allowed to do versus, well, what do we have to get consent for? And, oh, by the way, we're talking about both federal and state. So it can become fairly cumbersome to navigate the rules and navigate the laws and understand kind of how everything falls into place. The idea when you're experiencing patient privacy is it should be transparent to you as a patient. And so while you may have experienced it, it may not necessarily be evident all of the things going on in the background that are necessary to truly protect your patient information. And so kind of the first thing we have to do is we have to look at, where do we start? Again, you probably know a lot about how to keep information private. And you think about, well, if I don't talk to certain people or if I just use it in my daily operations, if I don't post things on social media, it's very simple. But as you can see in this screenshot, there are a lot of hidden traps that you can fall into that you may not necessarily think about, or you may not necessarily understand how can that be an issue. And so what we'll do is we'll kind of walk through the general rules that you're going to be playing within and some of the high-level concepts, and then I'll talk more specifically about some specific pitfalls that you'll likely encounter frequently in your daily operations based on what we've experienced with a lot of our clients. So you're probably very familiar with the term HIPAA, or you've heard it, and that is the fundamental place that we have to start, and that's the federal privacy law. It's known as the Health Insurance Portability and Accountability Act. When it was passed in 1996, it created 4 different health information standards. It created transaction and code standards, privacy standards, security standards, and national identifier standards. Most healthcare providers are only going to concentrate on the 2 of the standards, the privacy and security standards. And these were basically developed to increase and protect the confidentiality and availability of a patient's private information, or PHI, as you might have heard. The regulatory body that's responsible for enforcing HIPAA is the Office of Civil Rights, which is part of the Health and Human Services of the federal government. HIPAA is important to understand as a foundation because, as you saw on that previous screen, fines can be very significant under HIPAA. For HIPAA violations, they're determined on a tiered basis from a civil penalty structure, and they can range from $100,000 to $50,000 per violation or per record, and with a maximum penalty of $1.5 million per year for each violation. So as you can imagine, the number of violations that are identified can quickly create a significant amount of fines. There are also criminal penalties, and that typically involves more of the very fraudulent or criminal activities that you can imagine. It's not necessarily going to be your accidental disclosure issues. It's going to be more people stealing identity theft, those sort of things. Just to give you an example of the fines, just recently in 2016, Anthem settled for $16 million, which eclipsed the previous high for the OCR and recovery of $5.5 million. So $16 million in HIPAA fines for their violations. So they can get up there pretty quickly, as you can see. It's a per violation, so you start compounding that, and it can become very expensive. That's not to, forget about the reputational damage that you're going to incur from not protecting people's patient information. In 2009, Congress passed what you might have remembered, the stimulus package. It was known as the American Recovery and Reinvestment Act. Within this act were some enhancements to HIPAA, and it's known as the HITECH Act. And it did a lot of different things. It added a lot of different nuances to HIPAA, most important of which were stronger enforcement actions. OCR created an audit program to audit covered entities and business associates in their HIPAA compliance. And so it really stressed enforcement of HIPAA and its rules. One of the things it also did was it extended direct liability under HIPAA to business associates. Previously, business associates were only contractually obligated to follow HIPAA through what's known as a business associate agreement that covered entities have. But the HITECH Act extended direct liability to these business associates. Just kind of real quick, business associates, you might have heard that term before. So a business associate is a person or organization that's not a member of a covered entity's workforce. And so workforce members are what you traditionally think as employees, volunteers, trainees, can be other people who conduct certain things under the direct control of the entity. Doesn't matter if they're paid or not. Those are your workforce members. Business associates are the third parties that perform services. And what they do is they perform certain functions or activities on behalf of the covered entity that involve the use of PHI. And so you can think of billing companies when they bill on behalf of a medical practice or medical spa. If you have commercial insurance, those billing companies are business associates, or if they process claims, they're business associates. It can also include those persons or organizations that provide certain services to a covered entity that involve the use or disclosure of PHI. And so this can be attorneys to the extent that they need PHI to help perform services, so a lot of personal injury attorneys. It can be accounting if they need it. It can be management. So if you have an MSO structure, the MSO is considered a business associate of the medical entity. And it can be financial services as well. That's a little bit nuanced, but it can be those entities as well. You're not considered a business associate just because you perform services on behalf of someone, of a medical practice or someone who has PHI, doesn't automatically qualify you as a business associate. So if your functions or services do not involve the use of PHI, like for instance a landlord, then you're not a business associate. Or if your access to PHI is incidental, or if at all, then you're not a business associate. If you have more than incidental or continuous access to PHI, so a lot of your web vendors, cloud-based vendors are considered business associates. When this rule first came out, Amazon was very resistant to the idea that they would be considered a business associate for hosting PHI in the cloud, but they've since come around and they recognize that, yeah, we are technically business associates. Covered entities can be business associates for other covered entities. So two medical practices, one could potentially be considered a business associate of the other medical practice. Another thing that the HITECH Act did, and I'll jump into this a little bit more in a few slides, is it added the breach notification standard, which requires covered entities and their business associates to notify patients after an unsecured PHI is compromised. And I'll get a little bit more into detail of that in a minute. So HIPAA is the federal floor for privacy protection. We also have to look at state laws. And where this comes into play is on two fronts. So state laws that are contrary to HIPAA. So it is impossible to comply with both the state and the federal requirements, or if compliance with the state law is an obstacle to compliance with the federal HIPAA, well, in that case, federal HIPAA preempts state law, so you follow federal HIPAA. Now, on the other hand, if the state law is related to privacy of PHI, and it's simply just a more stringent standard, it's more strict, it gives greater protection to the PHI, in that case, HIPAA says you have to look to the state law. So what it essentially boils down to is you have to follow whichever rule gives the most protection to the PHI, whether that's federal HIPAA or whether that's your state law. And every state is different. Some states have specific laws that it outlines. Some states simply reference HIPAA. Some states don't really talk about anything in general. So it's truly going to depend on your state and figuring out kind of where where the gaps and things lie. For instance, in Texas, we have a specific law that requires a faster turnaround on giving people access to their PHI. So whereas the federal government provides a longer time frame and Texas says, no, you have to do it within 15 days, we have to follow the more stringent 15-day deadline. And there may be certain things in various states that do that kind of more stringent obligation. One particular area that you have to be very mindful of is with respect to breach notifications. Each state has some form of data breach notification process where it requires businesses that collect personal information to provide notice if there's a data breach. This is especially critical to understand because a lot of times in these state breach notification laws, it applies to a much broader set of information. We're not just talking about protected health information. We're talking about more broad information. And so you might not have a breach notification under HIPAA with respect to a certain kind of information, but under your state law, because of the definition, you do. You can also look at the definition of who has to comply with the breach notification law, and many times states will define that term in a much broader category, so it not only applies to you as a medical practice, but it might apply to you in general as any other kind of business. And so a lot of times with these breach notification laws, there's more of an expansive definition, but sometimes they'll say if you're a healthcare provider and you follow the HIPAA standard, then you're fine. So there is, sometimes the government thinks, oh, okay, you've already got your set of rules, we're not trying to complicate things, we're going to, as long as you follow what rules you're supposed to follow, then you're not bound by these rules. So every state's different, but you want to understand what those obligations and steps are. You're probably sitting there and you're probably thinking, wow, that's a lot to understand, that's a lot to do. Am I bound by HIPAA? Because some people say I'm not. I have state laws. How do those apply? What's preempted? What's more stringent? Where do I start? And technically, most med spas, if they're in the cash-based only business, may not necessarily be bound by HIPAA because of the definition of covered entity under HIPAA. So HIPAA defines a covered entity as every healthcare provider, doesn't matter what size, who electronically transmits health information in connection with very specific transactions. And these are things such as claims, benefit eligibility inquiries, referral authorization requests, other transactions that HIPAA has already established standards for. It's using technology, electronic technology such as email, does not mean that you are a covered entity under HIPAA. There has to be a transmission in connection with one of these standard transactions. So generally speaking, when you look at a medical practice, almost all claims nowadays have to be submitted to insurance or electronically submitted. That is a transaction standard that creates the obligation to follow HIPAA. But when you take it to just a straight cash-based business, not necessarily doing credit card transactions is the same thing. And so a lot of people think, well, if I'm just a cash-based business, then I don't have to follow federal HIPAA. I guess probably 10 years ago, the common metaphor or example of not having to follow HIPAA were the standard mom and pop solo physician out in rural area that was strictly paper. They did nothing but paper-based medical records, processing, billing, strictly medical, didn't have anything that was electronic. But nowadays, most things are all electronic, so you blur that line between, well, do I fall within HIPAA or not? Now, you don't have to get into that much of a detail to figure out do you fall outside of HIPAA, because what's happening is that states are now increasingly using HIPAA as kind of the standard of care with respect to patient information. And so it's being accepted by states. The most recent, earlier in Connecticut, where the Supreme Court recognized a private cause of action brought by an individual against a healthcare provider for HIPAA violations, and they used HIPAA as the standard with which that health provider should have followed. So the healthcare provider received a subpoena that requested production of medical records that was involved in a paternity suit. And so in response, the healthcare provider simply mailed a copy of all the medical records to the court. And as you can imagine, the other party, as a party of the lawsuit, got a hold of it and then started harassing the patient and just talking about what they found in the medical records, and just really a lot of harassing behavior. So of course the patient sued on multiple negligence counts of breach of contract to that healthcare provider. And so what the Supreme Court ended up saying was that the duty of confidentiality arises from the physician-patient relationship, very standard, and the unauthorized disclosure of confidential information that was obtained in that course of the relationship, so obtained during the treatment of that patient, it gives rise to a cause of action in both in tort and contract. And that's only unless that disclosure would have allowed by law. And so when it went to that concept, well, what is allowed by law, the Supreme Court pointed to HIPAA and its requirements for responding to a subpoena. And they said essentially that to the extent that it has been common practice in that area in Connecticut for healthcare providers to follow HIPAA and its rules and its regulations and its guidance on this certain matter, well, then that basically informs what the standard of care was, and that if there was a failure to meet that standard of care, then there would be negligence for not following it. So what that means and what that boils down to is that even if you're not technically governed by HIPAA, there's significant risk in not following HIPAA, because you can bet that personal injury attorneys or other malpractice attorneys or whoever represents individuals who are subject to some kind of embarrassing disclosure or unauthorized disclosure that causes them great, emotional distress or pain, they are going to point to HIPAA and say they never follow the federal rule, which everybody knows is what you should follow, and you're going to be behind the 8 ball in defending yourself. So I caution trying to fall outside of the realm of HIPAA or try to figure out a way to get out of it, because it may not necessarily be something easy to get out of. And so that's why, generally speaking, most providers follow HIPAA and then supplement it through whatever more stringent laws that are applicable to them based on their state. So, in looking at HIPAA, this is a great chart that I love to show to kind of show what exactly is protected health information, because that's what the HIPAA privacy rule does. It protects all individually identifiable health information that you hold as a medical practitioner, as a healthcare provider, as a medical spa, as a med spa, whatever your entity is. And this is what we call PHI. And you can read through the technical definition of PHI under HIPAA. Essentially, most important, PHI is not only written information, it includes any information conveyed orally or electronically. So it doesn't matter the kind of form. It's irrelevant for form, and it should be protected in the same manner regardless. So you protect it the same way, whether it's orally, whether it's paper, whether it's electronic. Privacy rule says you need to protect it. So when you're looking at this chart, you'll see on the left, there's a bunch of patient identifiable information. So very specific information that applies to a patient. On the right, you have health data. So various other things that relate to your health or to that can be created through a visit. In the middle, where those two intersect, that is what we think about as PHI. So a couple of examples. Medical record, laboratory report, hospital bill, those are PHI, right? Because each document contains patient identifiable information, contains patient name, probably social security number, maybe dates related to an individual, those identifiable information. But it also is associated with health data because it's a medical record. So that medical record is PHI. Now, if I told you, hey, I have a report that has the average age of health plan members showing as just 45, that by itself, even though we've aggregated from a bunch of PHI data, average member age of 45, that would not be PHI because it has no identifiable information. There's no reasonable basis to believe that we could use that information to identify an individual. So the relationship with health information, that is fundamental. So identifiable information alone, such as your name, your residence, your phone number, things that you might find in a phone book, for instance, that's not PHI. It's when you connect that with the health condition, the health care provision, payment information, visits, those sort of things that relate to health data. When you combine those two, that's when you get PHI. So I mentioned earlier with HIPAA, there's a privacy standard. The privacy standard, the basic principle is you may not use or disclose PHI except for two instances. If the privacy rule permits or requires, or the individual who's the subject of the information authorizes you in writing. Very important, there are only two instances in HIPAA where disclosure is required. That's to a patient when they're exercising a HIPAA right, and that's to the federal government for HIPAA investigations. All other uses and disclosures are permissible, meaning you don't technically have to comply with it. Now, there are reasons why you may want to disclose or use PHI to help facilitate certain healthcare operations, but you're not required to under HIPAA. Again, going back to the states, there may be a state law that that requires you to do something different with respect to a patient, or there may be things that restrict you from doing things that are otherwise permissible. Again, you have to kind of figure out what gives the most protection to an individual's information. With the privacy standard, typically you will hear of a privacy officer. That is the designated person who's going to be responsible for developing and implementing the policies and procedures for the privacy rules. They're going to be responsible for oversight of training, compliance efforts. They're the gatekeeper with respect to HIPAA. So when you hear privacy officer, they're the main person that's responsible for making sure that the organization follows HIPAA and has all the proper things in place and all the training of employees. The security standard, the basic principle here is you've got to maintain reasonable and appropriate administrative, technical, and physical safeguards for protecting electronic PHI. So security rule, it protects a subset of information. So whereas the privacy rule, as I mentioned earlier, covers all PHI regardless of form, the security rule only applies to electronic protected health information. ePHI is sometimes what you might hear it called. It doesn't apply to PHI that's transmitted orally in writing. And so here with the security standard, very similar to the privacy standard, the security standard requires you to appoint a security officer who is responsible for development, implementation of the policies and procedures that are going to set about the standards to comply with the security rule, as well as overseeing all of the the rules, the training of employees, and everything with respect to the security rule issues and obligations. You do have to have security policies and procedures that talk about the administrative, technical, and physical safeguards that you have in place. The most important one, the very first step that you have to do is the risk analysis. HIPAA requires you to conduct a risk analysis, and it's part of your security management process. Basically what this does is this is where you look at your organization as a whole and you try to identify all the EPHI, all the electronic protected health information that is vulnerable to threats and attacks, and how likely those threats or attacks could be. So you're going to look at the likelihood and impact of potential risk to EPHI. You're going to implement security measures that are going to address those risks that you just identified. You're going to document the measures that you've just implemented and the rationale behind why you're doing so that if someone comes in for an audit, they understand your thinking. And you're going to have to maintain continuous, reasonable, and appropriate security protection, so continually audit it. The risk analysis is an ongoing process. You regularly review records to track EPHI, you detect security incidents, you're going to periodically evaluate whether the rules that you have in place are effective and doing what they're supposed to, protecting EPHI, and you have to regularly reevaluate any potential risk to EPHI. If you add a new networked device, you should conduct a new risk analysis to say, okay, well, what additional threats and attacks are possible with respect to this particular device coming online? I can tell you that the risk analysis is going, if you ever are subject to a HIPAA audit or investigation, the risk analysis is going to be the first thing that they ask for. And so it's critical and important. Now, HIPAA recognizes people come in, the entities come in all shapes, sizes, resources, and so there is no, this is what you have to do, follow this, and you conduct a risk analysis. The security rule is designed to allow flexibility for organizations and allow them to identify what should be implemented and how, and so there are no set rules. So this is probably the most difficult aspect of HIPAA compliance, is when people start trying to work through the security rule standard, because you can go online and you can buy templates. And you can go online and download free templates and slap your logo on it and stick it in the corner. But unfortunately, it's very difficult for anyone to look at those forms and say, does that accurately reflect your network, your EPHI, your thinking behind risk and vulnerabilities? Because it has to be customized. It's meant to be customized. It's meant to work with your IT department to figure out how are we going to control certain aspects of access to EPHI or transmission of EPHI. So I caution always against just going online, buying forms, slapping a logo on, sticking it on a shelf, and saying you're HIPAA compliant. You have to be very careful with that, because it truly has to represent what your organization looks like from a network and technology standpoint. I mentioned earlier the breach notification standard. The breach notification standard requires, whenever there's a breach of unsecured protected health information, that certain notifications be provided. And so what is a breach? So a breach is an impermissible use or disclosure that compromises the security or privacy of PHI. And there are three small exceptions, but I'm not going to get into the details of that. The key here, though, is under HIPAA, an impermissible use or disclosure is presumed. There is a presumption that it is a breach, unless you go through the process to demonstrate that there is a low probability that the PHI has been compromised. And this requires you to do a risk assessment. You have to look at the four four important factors. First, the nature and extent of the PHI involved, including what type of identifiers and likelihood that people could re-identify it. The more sensitive information, the higher the threat. Whether the unauthorized person who used the PHI or to whom they were disclosed, who was that? Were they another entity that's bound by HIPAA? Well, maybe your threat goes lower. Are they just someone off the street that got the wrong email or letter? Well, maybe it's higher because they could use that for other purposes. Maybe they're a hacker, definitely a high threat. The third one, whether the PHI is actually acquired or viewed. This can, this depends on the method of transmission or disclosure, but you have to look at, well, do you have a reasonable basis to believe that it was never viewed or never accessed? And then to the extent to which there's a risk that to the PHI can be mitigated. And so is there a way to mitigate the risk? Can you get it back and ensure that it's not going to be compromised? Or is it gone forever and you have no ability to get it back? So you have to walk through those four factors to figure out, is there a low probability? Remember, the presumption is there is a breach. So you have to go through this process and document your decision on whether you believe there is actually a low probability, and you have to be able to defend that action should anybody ever come and audit or request to see information regarding that breach investigation. Now, you do have the discretion to provide breach notification without performing that risk assessment. So you can just say, we're just going to take the step to notify them, and we're not even going to try to go through that process. A lot of that will depend on kind of the nature and severity of the breach. What's important, and this gets into technology, is the breach notification rule, it only involves unsecured PHI. And so that's PHI that has not yet been rendered unusable, unreadable, or indecipherable. So for instance, if someone stole a set of data that is encrypted and the only key available is something that you have, well, then that's going to be secured PHI. You don't have, that's not going to be considered a breach notification requirement. HHS has said there are only two ways, two technologies, two methodologies that you can essentially secure PHI for breach notification purposes, and that's encryption or destruction. So for papers, you've destroyed it, shredded it, whatnot, or for electronic, you've encrypted it. And so, just keep that in the back of your mind. A lot of people don't want to do encryption. It can add a secondary layer, but it's highly recommended. There's some discussion whether encryption is required by HIPAA or not, and I've had these discussions with both a HIPAA expert as well as a former employee of the local HHS office. And we've had a discussion of whether encryption is or is not required. Technically, it's what's called addressable, so it's not required, but for all intents and purposes, the government's going to require you to have encryption. Once you do have a breach, you have a breach, you have to notify. There are several different layers of notification. Individuals, HHS, you have to notify regardless. The timing depends on how big it is. So 500 and more, you have to do it without an unreasonable delay. For less than 500, you just have to do it on an annual basis. I think it's within 60 days at the end of the year. The media, you have to notify under HIPAA if there's more than 500 individuals affected. And then there may be others. So in Texas, you have to notify the consumer agency. There may be some public agencies you have to notify, the Attorney General, depending on your state notification laws. So you may have other breach notification requirements as well, so just keep that in mind. And then the content, most states kind of follow the same content. It's essentially to give enough information for someone to understand what's happened, what's going on, and what they should be anticipating to experience. Under HIPAA, there are several rights that patients have. I mentioned these earlier as one of the issues that require disclosure of private information. Notice of privacy practices, that's the right to receive a notice about how you're going to use and disclose their health information. If you've gone to the doctor, you've probably seen their notice of privacy practices. You probably had to sign saying you've received it and read it. so you're probably familiar with how those look. Access and copy, patients have a right to have an access and copy to their records. There are some exceptions, but patients have a right to inspect, review, and receive a copy of the medical records. Amendment, if they feel like, if a patient feels that information in their medical or billing record is incorrect, they can request a change, and there's a certain process to go through that, but there is the ability to request amendment. Confidential communications, a patient has a right to request that the provider communicate with them in an alternative means or location, and you have to comply with reasonable requests. Accounting, an individual has a right to receive an accounting of certain disclosures, of things that are uncommon basically, and then there's also a right to receive an accounting of electronic health record disclosures, and there's a certain time frame and process and things to go through that if you ever receive those kind of requests. And finally, restrictions. An individual has a right to request restrictions on uses and disclosures of PHI for certain things, and you don't have to necessarily agree to them, but if you agree to them, then you have to abide by them. So that's HIPAA in general. That's the general standards that we talk about, and that we are kind of our federal floor again, if you will, of protections. And as I mentioned at the very, very beginning, a lot of times that then kind of coincides with the reality of business and operations, and how do we reconcile the two. And so there are some pitfalls that I want to go through and talk about and give examples of and just kind of illuminate. I'm not going to talk probably about all the things that we could talk about. We could spend 2-3 hours on all the various HIPAA issues that can arise, but I picked some of the more frequently discussed topics that we see on a daily basis. The first one are photographs. So, a lot of med spas are driven by before and after photos or results photos or case photos, and a lot of times, the idea is, well, if we're performing a service for a patient, we want to be able to use their photos to help market and promote. And the first question that I always get is, well, it's not really PHI, right? It's just a photo of, some part of their body maybe. Well, technically, PHI is, identifiable information again. And so the question I always have is, well, true, you might not be able to identify a person by that picture, but can you say with 100% accuracy that no person looking at that photo would be able to identify it? And so, the easiest example is maybe they have a little butterfly tattoo that shows up on the photo. Well, arguably that's going to be identifiable because someone's going to recognize it, or there's a reasonable basis to believe that someone looking at that picture could say, oh yeah, I know that person because they live in that general vicinity. I know they go to physicians or med spas around that area, and I know that they have that tattoo. So I always caution against whether they are truly de-identified or that takes them out of the context of PHI. So you got to be very, very, very careful if you're going to rely on that. There may be some ways that you can make them de-identified, but that's something you want to explore before just considering them de-identified, which falls outside of HIPAA. So under the assumption that they are governed by HIPAA now, there are two aspects that kind of get confused, and that is consents and authorizations. So consents are kind of in two different ways. So consents can be done through, I'm consenting to allow you to take my photos to become a part of my medical records. That's kind of the first level of consent. It's the consent of the act of taking the photo. But then there's a secondary consent or authorization, and that's, okay, I want to post your photo online. Can I do that? Technically speaking, because that is a disclosure to the outside world that is not otherwise permitted under HIPAA, you have to get a HIPAA authorization. There are a lot of forms out there that call them just general consents that aren't technically HIPAA authorizations, but under the technical rules of HIPAA, you have to have a HIPAA authorization because you are disclosing information to the outside world. And that is not permitted, or that is not a permissible disclosure under HIPAA. So you have to get a HIPAA authorization. HIPAA authorizations are a very specific document. They're not just consent. It is a specific document with a number of elements, And there are several different requirements that you have to have. Some states go further and require a little bit of a nuance to those requirements. So again, you'll have to check your state laws on that. More importantly, generally speaking, marketing is a separate issue. So when you're posting them online, your purpose is marketing. And there may be state laws, such as Texas, that state that there has to be consent or authorization, whichever is more stringent, in order to use a before and after photo or use PHI for marketing purposes. So we get that question a lot. We fall into that trap a lot. So you want to be very careful with just saying, sign this consent that we can take your photo, and believe that that's giving you the right now to post it online. It's a two-step process. You got to make sure you have everything, because fundamentally the HIPAA authorization, what that is doing is that is saying, I have informed the patient as to why I want to disclose this, and I need their specific authorization to do so. And so what you don't want to do is have this mishmash document or compound document that confuses the patient because it's convenient for you from a business perspective, but the patient doesn't really recognize what they're truly signing up for. You also, from this two-step process, what I always talk to clients about is you don't want to make your treatments and services dependent upon these people giving up their right to their photos being posted to the world. You want to give them the sense that they have a certain amount of control. So consent, we're going to take your pictures for before and after photos for your medical records. Oh, by the way, here's an authorization. We would like to use these photos on our website or on our email marketing campaigns. We would love for you to allow us to use these photos as you see them. We won't use any other identifiable information. Let us know if that's okay. You really want to treat those two different ways, because that's going to be the best way to get some goodwill from the patient and not feel like they're having to sign their life away and their likeness away and be exposed to the world just to get done what they need to do. One example of before and after photos that we've encountered that you need to be very mindful of, even if you claim or believe that they're de-identified, even if you believe or think that you have the right to post them without consent or authorization, whatever the case may be very careful of the metadata behind that photo. We had a client who forgot to scrub the metadata on their photo, and so when they posted it on their website, there's nothing identifiable in the picture. There's nothing identifiable around the picture about that patient. But because of the metadata, when that patient Googled her name, that picture came up because Google was able to find that information. So be very, very careful and have a very specific process, whether it's you, whether it's your marketing company, whether it's your website company, have a very specific process to ensure that you've scrubbed that photo of all identifiable information associated with that photo, because you don't want that Google issue to come up. The other issue that we encounter a lot is with respect to social media. So you can imagine common social media HIPAA violations. You post images and videos of patients without their consent. So you take a picture and you post it to Instagram. There's no consent, no authorization, just let's post it. People involved in the organization gossiping about patients on social media accounts. Posting any information that can allow an individual to be identified. So you may not specify an individual, but you may talk generally about this person to an extent that you give enough information that someone can identify them. Sharing photographs or images they're taking at the facility, and patients happen to be in the background. Or you take a picture of a couple of nurses standing next to a desk, and on top is a medical record plainly viewed that has the name of a patient on the top. They're accidental, but they're still HIPAA issues. Sharing photos, videos, texts on social media platforms with a private group, again, just because it's private doesn't mean it's not a HIPAA issue. Another issue that you can find yourself in, you got to be very careful, is if you have separate policies on HIPAA compliance and social media, because they're not always going to mesh. As you can imagine, HIPAA compliance is typically done by individuals with one specific item in mind: compliance, follow the rules, what are the regulations. Whereas Social media guidelines may be how do we get out to the world, marketing. It's a very different concept. And so if your policies don't talk to each other and they're not incorporated into each other, you can find yourself with real issues because someone may be thinking they're following the social media guidelines, and yet they're not aware that, well, HIPAA still applies. You got to follow those guidelines as well. So be sure that if you have those two set of guidelines, that you look to see if they actually, really do incorporate well. One example that we found with social media was a Los Angeles hospital used a temporary staffing company to provide an individual. And that individual went on their Facebook page and had this quote, "Funny, but this patient came in to cure her VD and get birth control." And along with this, she posted a photo of the patient's medical record, including her name. Automatically, as you can imagine, a bunch of people started saying, that's a HIPAA violation. You're violating that patient's privacy. And the employee responded, and I quote, "People, it's just Facebook, not reality." So you have to make sure your employees are trained, even if they come from a staffing agency, even if they're temporary, even if they're volunteers or they're coming in just to help. You have to make sure that they're trained and they understand what HIPAA is. And again, if you have separate HIPAA and social media policies, you want to make sure that they're in line with each other and that there's no gaps or conflicts. So another one that we often encounter, and this is probably the most frustrating one, are review sites. As you can imagine, people post on a variety of review sites regarding their experiences with med spas or specific healthcare providers. They'll go on Yelp or RealSelf, or they'll go on the Facebook page, or there are so many opportunities out there for people to talk about their experiences. And so you're going to get the urge to see a bad review, and you're gonna have an urge to respond. I mean, it's human nature. You want to respond and tell the world how they're wrong, but you have to remember that just because they put a review online with whatever information they put on there, that doesn't waive their HIPAA rights. It doesn't permit disclosure of specific patient information. So you still have to be very, very careful and treading with regard to HIPAA. So, generally speaking, what we say is, if you're going to respond at all, you want to respond in a very generic sort of way. You want to, focus on the generalities about your med spa. You want to stay away from specific information about that patient. You want to talk about, the experience of an individual, if it's pointed to an individual. You want to be very, very generic. What I will also say is you want to be careful about whether you even need to respond at all. So, for instance, we had a client that had a very negative Yelp review posted, about him, and I talked with him through these issues, and obviously he had the urge to want to respond. And one of the things that was also pointed out by his marketing company was that this person had only written 3 other reviews, didn't have any friends, and so eventually, most likely, that negative review was going to get filtered and moved to the not recommended section. So if this is a one-off thing, if you have 5-star reviews all over the place and this one person is the bad apple, maybe you don't respond because it's naturally going to work itself out to go away, and people are going to look at it and say, 49 5-star reviews and this 1-star review, obviously that person has a specific issue that isn't reflective of everybody else in general. So want to be very careful and look at that. You also want to be very careful with your advertising rules because you don't want to say anything that could be led to be untruthful, deceitful, or misrepresentation under licensing board advertising rules. So here's an example that of something that happened. A patient went on a review site, had all this negative stuff to say about this person, talked about Dr. X and how just completely messed everything up. And of course the patient then out of spite forwards the review to Dr. X and staff and says, look what I wrote, and I'm going to tell all my friends not to come here, and I'm going to post more negative reviews and make sure no one ever comes to your office again. Well, obviously, Dr. X went home, saw the post, as with everybody can imagine, had a very, very visceral reaction and thought, you know what, I'm going to put this patient in place, I'm going to set the record straight. So Dr. X went ahead and provided a detailed accounting of the patient's medical history, including the issues she had with drinking and being overweight. You know, show her and give the truth out to everybody. And this is my reaction if anybody ever comes and tells me that story or shows me that they posted that. So you have to be very careful. And again, you know, it can work itself out naturally, and so you want to look at that. But if you do respond, you want to make sure that it's a very generic response and that you tread very lightly, because their review does not give you permission or authorization to disclose to the world things about their medical care. It's unfair. It can be frustrating. It happens a lot in this industry. I've dealt with a lot of clients who have seen it, but you know, it's something that can be dealt with, and you can either look at it to take care of naturally, or you can just kind of wait and provide a generic response, and hopefully people will you know, just look to your response and think, okay, then I understand what they're saying. The last pitfall I want to talk about real briefly is portable devices. Obviously, we have the cloud, and people can access information from a variety of devices: iPads, iPhones, Android devices, you know, smart TVs, you name it. So there are a lot of benefits to you know, portable devices. Completely understand. But if you're going to permit portable devices, there are going to be data security concerns. And this is going back to that risk analysis. You have to look at where the threats and vulnerabilities are with respect to those devices, and you have to set policies and procedures to ensure that you're going to protect any information that makes it to those devices. And so, you know, it's, again, you know, people taking home their phones. Are they able to access information on their phones? Do you restrict them from doing that? What about iPads? Do you have an inventory system to track where they are, so that a person can't say, I'm going to finish my notes tonight, so I'm going to take this iPad home with me, leaves it in the car while they run to the gas station to buy a Mega Millions lottery ticket, and they come back out and, oh my gosh, there's no iPad. And now you have a full-blown HIPAA issue, breach investigation, lots of liability at risk, creates a big headache. So knowing those rules and making sure you have rules to implement for portable devices is critical from the security aspect of it. Here are just some examples of stolen devices. Examples, so MAPFRE Life Insurance Company, they were fined $2.2 million by OCR for a lost device. So they had a data storage device that was stolen from its IT department. It wasn't encrypted. It had, you know, names, dates of birth, social security numbers, and it was about 2,200 people that were affected. And so when OCR investigated them, they found that they failed to conduct a risk analysis and implement any kind of plans, contrary to them knowing that this was going to be an issue, and they failed to deploy encryption or some kind of alternative measure to protect that information. So they were fined $2.2 million for those failures. CardioNet in 2012, it was fined $2.5 million when a workforce member's laptop was stolen from a parked vehicle outside of their home. So they went home, they parked the car, they left it overnight or during the day, and it was stolen. And it contained PHI of 1,400 individuals. And when OCR investigated it, they found that CardioNet had not done a sufficient risk analysis to figure out how to put in proper security standards with respect to the portable devices. MD Anderson recently was fined $4.3 million. And this arose from the theft of an unencrypted laptop from the residence of an employee and the loss of 2 unencrypted universal or USB thumb drives. So again, someone broke into their home and stole these devices. And yet, because they were unencrypted ePHI of over 33,000 people, and they had found in their risk analysis that they needed to do something and they were high risk, but they failed to implement anything, MD Anderson was tattooed. So as you can see, portable devices are ripe for issues and ripe for exposure, and so you want to be very careful about those. So how do we prepare and minimize risk? Compliance officers, your privacy officer, your security officers, they can be the one and the same, but you want both of them on board or one person on board holding those titles, working very closely with IT and management to set about your policies and procedures to make sure that you're following all the various rules, both privacy and security. You want to develop these policies and procedures. Again, you can buy forms, you can download forms, but if they're not accurately representative of your organization and you don't actually follow them, it can be very, very, very big risk there. You have to train and educate your staff. There are training requirements under HIPAA. States may have training requirements. Texas does, and it's more stringent than HIPAA. You have to train and educate your staff on your policies and procedures, and more specifically, how it impacts their daily life. You have to enforce disciplinary standards. If they break the rules, you have to enforce the disciplinary standards. You have to show a commitment to those issues. You have to continually monitor and audit everything. This is HIPAA compliance is continual. It's not a one-time fill out a form, put it on your shelf, you're done. It's a continual, ever-evolving process that you have to make sure that you follow. When you do detect offenses, you have to have a response plan. You need to know who on your team is supposed to do what. You need to have practice certain ways of handling issues, and you need to have a correction action plan and be able to implement it. So you need to know how to mitigate, how to fix, and how to prevent. Communication. You want to communicate with privacy officer, security officer, management, but more importantly, legal counsel. You want to make sure that you communicate throughout the entire process to make sure you follow all the rules and requirements, and you do it in a timely manner. So from the very first time you learn of something, you need to start the process. And then insurance options, there are cyber liability policies out there that exist. You want to be very careful as to the exclusions and what they say. There can be some tricky language in there. They may exclude negligence, which if you don't have encryption, they could claim that that's negligence because people believe it's required. It could say that you have to have policies and procedures in place, and if you don't, then you're automatically violating your own policy. So there are policies out there available, but you want to be very careful and understand the language just like any other insurance contract. So with that, I know we have a few minutes left. There's probably a billion questions going on in your mind. There's a lot of different issues. I'll be happy to answer questions.
I understand that PHI is not permissible in marketing. What about sharing PII with marketing firms?
So the only way that you can share information with marketing firms is if it's de-identified. There are only two methodologies that are specified by HHS and OCR and how you de-identified information. Because naturally you come into that PII through the provision of health care, and so by virtue of you having it, it's now become protected, so you're not going to be able to share that because you're saying, here's PII that's associated with my interaction as a medical provider to this individual. So it's by default PHI when you're holding it. So there's only two methodologies to do that, and you can there's HHS has some good guidance on those two methodologies.
Thanks so much, Jay.
Thank you.